It's a topic that many people may not want to face, but when you care about what happens to your family and how they're cared for when you're gone, creating a will is a necessary step. So we've invited attorney Jerome Deener, a senior partner with Deener, Hirsch, and Shremenko, to share some insight into the process. Hello there.
Morning.
Thanks for being on the show.
Thank you.
It's okay to call you Jerry, you say?
Absolutely.
Great. So who needs a will?
Well, almost anybody needs a will. For the younger people in your audience who may have minor children, a will's very important. For example, the picking of a guardian for their minor children. What is the role of a guardian? The role of a guardian is the person who would actually do the bringing up of that child in the absence of both parents.
Got it.
So bringing up includes emotional needs, educational needs, health needs, and whatever
that child needs.
Yeah, that the parent otherwise would have provided. Who is that person? Nobody's going to be perfect. But it's a decision that should take the most time in dealing with younger persons' wills.
So it's really important, really thinking about who that guardian is going to be. I know you also said that we have to be careful with the age of maybe the guardian because...
Yeah, the role of the guardian in our state, the state of New Jersey, lasts until the child is age 18.
Okay.
So in the case of very young children, it could be a long period of time, and many times the people will choose their own parents as a guardian.
Right, the grandparents.
So that could be a good choice, but then if they are of older age, we should be considering an alternate guardian as well.
Something to think about.
Right.
So that will is used, you know, the guardian is used to establish the basis of who's going to get my child in my will.
And who will have the emotional care
for that child. Got it. Now you said another decision is to select a trustee.
Okay.
What is that?
We don't want funds to go to a child immediately.
Okay.
Most young children obviously lack the maturity to handle any kind of funds. So the role of the trustee is to hold the funds for that child, invest the monies, and to use it. The words that we use most often is that the trustee is to use it for the child's needs of health, maintenance, support, and education.
Okay.
And that covers just about everything.
So the trustee is the person that holds the money, then?
Holds it and invests it and disperses it for the child.
Which leads me to maybe needing a trust. Where does that tie in with the trustee and having a trust?
The trust would be created under the will. Okay, the will would say that if my children are below a certain age, instead of monies going out right to them, we are creating the trust in the will.
Okay.
And that trust is very specific as to when distributions are made, how they're to be made, and at what point the trust terminates. At what point does the child actually wind up with the money in his or her own hands? Got
it. Now, how again would that trustee come into play? Now, like, would that be a lawyer that's normally a trustee, or a bank, or a person? Would my husband be the trustee? Who would be a trustee?
Okay, I tell each of my clients, just as the word implies, a trustee is someone in whom you place your trust.
Got it.
It can be an individual.
Okay.
It can be a relative. It can be a friend, it can be a professional, and it can be an institution like a bank.
Got it. Are they the safest, the institutions, because they're impartial?
Well, the institutions are there. You know they'll always be there. They're very good in dealing with investment decisions. They're good in terms of dealing with whatever filing requirements there are for a trust, income tax returns, and that type of thing.
Right, because it can get very complicated.
But my usual recommendation is the human decisions, such as when do we actually make distributions for each child. I'd like to see somebody close to the family as a co-trustee if we're going to choose a bank.
Okay.
We can do that.
Now, a trustee, though, does that apply to both me and my husband? Say, if I passed, would he, how does that work? Or do we both need to pass in order to get the trustee?
Well, when it's going down to the children, most of the times it's when both parents are no longer surviving.
Got it.
Okay? There are, however, tax implications, and for tax reasons, depending on the circumstances, there may be a need for a trust for the surviving spouse.
Oh,
Otherwise, most of the time, funds go directly to the surviving spouse.
To the surviving spouse first, normally.
Or there may be a second marriage situation.
Right. What happens
where we
then?
want to, well, that's a good place for a trust, where we want to protect the surviving spouse, but we also want to protect so that the assets ultimately go back to the family or the children of the first spouse.
Got it.
So very often a trust is created for that reason.
So another crucial point where we would need a trust in, divorced families or remarriages in that situation.
Since 50% of all people have
divorced,
unfortunately gone through a divorce, and many of them have children from prior marriage. We see that quite a bit.
Okay, so that makes a lot of sense, though. So individual. Now, you talk about spray trust. What's the difference between the spray versus a standard trust?
Okay, if we have more than one child, getting back to the child situation, let's say there's 2 or 3 children in the family.
Got it.
Very often we'll suggest that the form of this trust is what we call a spray trust, meaning it's one pot, all the funds are in this one pot, and then the trustee just pays out to each child as each child needs the funds. And I tell the parents, think of it as though you're around. Nobody that I've dealt with keeps a chart on how much they give to child A versus child B. So let's you have it in one pot while you're alive. Keep it in one pot. But at some point, the trust, that one pot trust, will be divided among either 2 or 3 separate trusts, depending on the number of children.
Got it.
Or will go to the children outright.
Directly. Okay. Now, how about executors? Now, that's obviously different from a trustee.
The role of the trustee can go on for many years. Invest the money, pay out for the child's needs. The role of the executor is a 1 to 2 year function.
Got it.
The executor has got to gather up the funds. It's called marshaling the funds from a legal point of view. Pay whatever debts there were of the decedent. Pay the taxes, and then distribute the funds in accordance with the will.
So they're the ones doing the nitty-gritty of it?
At the beginning. It's a 1 to 2 year process.
Okay, then the trust would take over after that.
And many times the trustee and the executor is the same person.
Are the same thing. That's what I was going to ask you next. Okay. Now, you also say there's tax reasons for developing a will.
Yes.
So the government doesn't take all the money? Is that?
Well, here's how it
works.
That work? Okay, there's 2 sets of taxes. There's state taxes, and each state is different.
Okay.
And there's federal tax. The way the federal tax works is the first $2 million of all assets owned are exempt from tax.
Okay?
Oh,
well, that's encouraging.
So anybody with substantially under $2 million,
you're good to go.
we're not. But for people with assets in excess of $2 million, there are trusts under the will that can protect the taxes. If we do it right, we can make a husband and a wife can pass $4 million of assets to their children through the use of trusts.
Got it.
Tax-free.
Okay.
Okay.
Now, how should people prepare for a conference with an attorney before I develop my will?
Well, first, I have in mind who are the people that you would want to take over.
Okay.
Who would want to be the guardian for the children? Who do you trust to do that, etc.? And who would be the person or bank that would be the trustee?
And I would imagine you'd have a conversation with these people before you actually put them into the writing.
I always suggest
Don't want any surprises for these poor people.
But moreover, I also suggest to come to the conference prepared is to make a list of assets that are owned and how they're titled. That's important.
Okay.
What's in the husband's name? What's in the wife's name? What's in joint names?
What's
how much life insurance is there? And retirement funds, IRA, 401k.
Got it.
All these different assets have different implications in the planning process.
Okay, so that's a great place to start, is really developing my list of assets first.
Right.
That's where I should start.
And debts.
And debts. All right. Well, let's not forget about the debts. Right. We don't want to pass all of them on, too.
Right.
Well, maybe we do.
Well, you may have to.
Right.
By law. All right.
Well, thank you, Jerry, so much for being here. I appreciate this. I'm going to work on this. Thank you.
Okay. Thank you.